Hello, everybody, and welcome to Psyched Out, a podcast about all things psychology. We're going to keep the intro short because this is going to be a longer episode. I'm your host, Emily, and for those who don't know, I have a background in forensic psychology and law enforcement, which helps me provide unique insight on some of the stuff that we're going to be talking about today. Very quick housekeeping stuff. Over the next month or so, I'm going to be moving where I film my podcasts into a separate room in the condo. I'm going to turn it into a little bit of a podcast studio, finally cleaned it out. So if you want to help make that happen and speed up the process, please don't forget to like, comment, and subscribe. It really does help. And I am very happy to know that you guys can use me as a source of reliable information pertaining to topics in the Epstein files. Today, this is going to be the 5th installment of my Into the Files Epstein series. And we're going to go ahead and jump right in. I'm going to shrink myself down here. And I will be honest, a lot of this is going to be me reading documents because, again, I want you guys to have words from the horse's mouth. I don't want you to have the source be trust me, bro, because I think that's stupid and that type of content pisses me off. You should be able to trust where you are getting information from. And part of that is on me to show that, yes, I do have reputable sources. Every document that I have in here is from the DOJ website itself, specifically released from the Epstein files, so that is where this information is coming from. If I jumble up some of the things I'm talking about, I do apologize. I tried to upload these in chronological order, but I do think I got a little mixed up, so bear with me. But the first thing I want to talk about is the supposed suicide of Jeffrey Epstein. Now, this has been a big conspiracy for a very long time, and I will give you my thoughts and feelings on it. But first, we're going to look at the introduction to one of the reports, one of the indictments pertaining to the defendants, Tova Noel and Michael Thomas, who were the two prison guards that were supposed to be keeping an eye on Jeffrey Epstein. On or about August 10th, 2019, Tova Noel and Michael Thomas, the defendants, in dereliction of their duties as correctional officers at the Metropolitan Correctional Center, MCC, repeatedly failed to perform mandated counts of prisoners under their watch in the MCC Special Housing Unit. Instead, for substantial portions of their shifts, Noel and Thomas sat at their desk, browsed the internet, and moved around the common area of the SHU. To conceal their failure to perform their duties, Noel and Thomas repeatedly signed false certifications attesting to having conducted multiple counts of inmates when in truth and in fact, they never conducted such counts. As a result of those false statements, the MCC believed prisoners in the SHU were being regularly monitored and accounted for when, in fact, as a result of the defendant's conduct, no correctional officer conducted any count or round of the SHU from approximately 10:30 p.m. on August 9th until approximately 6:30 a.m. on August 10th. Let's see here. I believe this also pertains to this report. Yes, okay. On July 23rd, 2019, while Epstein was housed in the SHU, MCC officers responded to an emergency call and found Epstein on the floor of his cell with a strip of bedsheet around his neck. Michael Thomas, the defendant, was one of the MCC officers who responded to the incident. Epstein was subsequently transferred out of the SHU and was placed on suicide watch. Inmates placed on suicide watch are housed 24 hours a day by a staff member or a specially trained inmate companion, which sounds really weird. I don't know how you train other inmates to be like suicide prevention, but here we are. Epstein remained on suicide watch for approximately 24 hours and then was transferred to psychological observation until July 30th, 2019. Psychological observation is less restrictive than suicide watch, but inmates are still housed in the hospital wing of the MCC and watched 24 hours a day. On July 30th, 2019, Epstein was transferred back to the SHU and at the direction of the MCC's psychological staff was required to have an assigned cellmate. Epstein was also assigned to the cell closest to the correctional officer's desk in the common area of the SHU, which was approximately 15 feet from the cell. Conducting the required institutional counts and 30-minute rounds in the SHU were also part of the MCC's procedures for ensuring the safety of inmates, including Epstein. So, those who don't know, I did a brief stint at a juvenile detention facility. I'll read this document in a second as well. And there's a lot of similarities between the way prisons operate, jails operate, and juvenile detention centers operate. Obviously, there's some major differences because one pertains to kids and the other pertains to adults, but the system is still fundamentally the same. So what you have in all jail settings, all, prison setting is something called a control room. And a control room is manned by correctional officers who have cameras all over the place, who are answering phones, doing cell checks, inmate checks. They're themselves not doing cell checks because they're in the control room, but they're checking off that cell checks were done, etc. So they are the eyes in the skies. They are very important. They are the ones that have the checks and balances where you don't accidentally open everybody's cell door at one time. You have to be very on top of it because the safety of correctional officers and other inmates depend on the people in the control room. So, what I learned reading some of the documents pertaining to Epstein's suicide is that somehow all of this got by the control room. So, as mentioned, Nova and Thomas were sleeping on the job. They were at their computer desk all night. And, that should be on camera. That should be noticed by the control room officers. So it's interesting to me that these two were shoehorned as the people directly responsible when it's really a systematic failure. Because the control room should have noticed and observed that things were not being done based on the cameras, and yet that didn't happen. On top of that, no supervisors were contacted. Nobody went in at any point outside of the two correctional officers, Thomas and Nova, that were already in there. I apologize. I've been saying Nova and it's Tova. I'm combining the first and last name. Tova and Thomas were the only two in there. Now, I do understand that, doing rounds, doing cell checks, things like that, it's really exhausting, especially with all the stairs. If you're on graveyard shift, it sucks. It sucks a lot. But it's also very important to do because, you want to keep people from killing themselves. Now, what I find strange, particularly strange about Epstein's suicide, is that it's very clearly documented he was a mental health risk. He was a suicide concern. That's why he was in observation for 24 hours and then under psychological evaluation. Now, what amazes me is that he was still allowed to have a bedsheet and items that he could kill himself with. Now, I don't know exactly how it works in prison, but in juvenile detention, if a child is put on suicide watch or is a suicide risk, they go on SIP, which is a suicide intervention program. And what that means is they are not allowed to have items, including bedsheets or blankets, that they could use to kill themselves because you are operating in the interest of protecting and preserving their life. So when I say that, I mean there were girls that weren't allowed to wear bras because they could try to hang themselves with it. There were girls who were not allowed to have the longer tube socks. They had to have the short no-rise socks. They were not allowed to have bed sheets or blankets or pillowcases. They had thick green blankets that there's no way you could kill yourself with, and you could only use it as a blanket or fold it up and use it as a pillow. Cell checks were done repeatedly so that they couldn't have items that they could use to kill themselves. Their toothbrushes were this big around so you couldn't sharpen it to kill yourself. It's just weird to me that knowing the history Epstein had and how concerned they were that he might kill himself, that he was provided with items that would allow him to do so. And again, the fact that none of this was detected by staff on hand is a little bit weird. The other thing that I find suspicious about this is the fact that from what I can tell, and I haven't done a whole lot of research on it, Thomas and Tova have not had issues like this reported before. It seems like this was out of character. Now, I could be wrong. Again, I have not looked specifically into them as employees, but when you look at the lengths of their careers, they were there for a significant amount of time where if they had consistently kept up this behavior, it would have been noticed and it would have been documented, because there's no way you can work at a facility like this for years and not run into problems if this is what you're consistently doing. So it's odd. It is very, very strange. Now, I can't say a definitive answer on whether or not Epstein killed himself. My opinion at this moment, based on the information and how weird the whole situation is that he did kill himself, but he was allowed to do so. And I think it was intentional by staff and the facility to let him do this. I don't think they really cared that he was going to kill himself. Obviously, there is a pecking order when it comes to sexual predators in jail and prison, things like that. Murderers are more respected than sexual predators. So it may be the situation of, well, it happened, oh well. But the other thing, too, that's weird is Epstein was supposed to have a cellmate with him to keep this from happening. So the fact that all of these factors lined up in a way that allowed him to kill himself despite his mental illness, that was documented by the prison, is really, really weird. And I do think it's a reason why people are so interested in his autopsy and things like that. I myself have not gotten to see the autopsy. I haven't made it that far. But it is interesting, and it's why there's a lot of speculation, because it really was the perfect storm. So let's read this document really quick. During the time period from 4 p.m. on August 9th to 8 a.m. on August 10th, the officers on duty in the SHU, including Tova Noel and Michael Thomas, the defendants, were responsible for conducting 5 institutional counts. 4 p.m. and 10 p.m. on August 9th, and 12 a.m., 3 a.m., and 5 a.m. on August 10th. Noel, Thomas, and the other officers on duty were also responsible for completing paperwork attesting to each of those counts. While as detailed herein, count slips were completed for each institutional count. In fact, not a single one of those institutional counts was done. Tova Noel, the defendant, and Officer 1 were responsible for conducting the 4 p.m. institutional count in the SHU. So again, there's other officers that are involved in this. It's not just Thomas and Tova. And as video from the MCC's internal video surveillance system makes clear, Noel and Officer 1 did not perform the 4 p.m. count. Nonetheless, Noel and Officer 1 completed and signed a count slip that falsely stated that the 4 p.m. institutional count had been performed. In reliance on that falsified account slip, at approximately 5:03 p.m., the control center cleared the 4 p.m. count. So again, there's other people involved here outside of Tova and Thomas. In my opinion, those two are just the fall guys. Now, I can't definitively prove that, so I'm going to say very clearly that that is me speculating based on experience and personal understanding of how these systems work. That evening, Epstein returned to the SHU from his attorney visit and was escorted into his cell by Tova Noel, the defendant, and another officer at approximately 7:49 p.m. Noel and the other officer left the tier in which Epstein was housed immediately thereafter. So, his suicide is going to be a point of contention for a long time. I know there's some AI videos and AI photos floating around out there where they're like, oh, look, he's in Israel, which may be possible given a lot of the Israel ties he has. But I don't know. It's difficult because it's really either they faked his death and he's not actually dead, or it's he did die but it was allowed to happen and there were people in on it. Because this was such a perfect storm, it just doesn't accidentally happen like this. You don't have this many people complicit in, a sexual predator killing themselves unless they know about it ahead of time. Okay, so what we have here is, I'll try and read this as fast as I can while still being legible to you guys. But basically, this was an investigation that happened after Epstein's death. And it was revealed that the security issues in MCC were astronomical, to the point that phones were being smuggled in, all sorts of things were being smuggled in. And this is a high security prison. So this type of stuff should not be allowed to happen, which also leads me to believe that there are people who are aware of things that are going on and are allowing it to happen. So let's read this really quick. This March 12th, 2009 photo shows the Metropolitan Correctional Center in New York City. The federal jail in New York City prison and jail are different. It is a jail. I apologize. Prison is when you're convicted. Jail is where you're being held. So I apologize. The federal jail in New York City, where wealthy financier Jeffrey Epstein took his own life, is on lockdown as authorities try to determine whether someone smuggled a gun inside one of the most secure federal jails in the country. That's according to two people familiar with the matter who spoke Friday to the Associated Press. The Justice Department has opened a criminal investigation into potential misconduct by guards as officials keep inmates locked down at the federal jail in New York, where the financier Jeffrey Epstein killed himself over the summer. People familiar with the matter told the Associated Press. The investigation at the Metropolitan Correctional Center is focusing on the flow of contraband into one of the most secure jails in America and is being led by federal prosecutors from the U.S. Attorney's Office in Manhattan, the people said. They were not authorized to discuss the investigation publicly and spoke on condition of anonymity. So what are some of the things other than the gun that may have been taken into the facility? Well, like I said, there was a lot going on there, but there were cell phones. There was other contraband as well. They don't really elaborate on it, but at the time that this was done, they did not find a gun. Now, obviously, a gun being in a jail like that would be very, very bad. It would not be good at all. But what this highlights and what this kind of lends to my theory and my speculation about the suicide is that there were enough people who were willing to look the other way to allow it to happen. And that's because there's so many officers in here that were allowing cell phones to be smuggled in, that were allowing other contraband to be smuggled in, because you don't just accidentally bring a cell phone into jail and go, oh, I just accidentally gave it to an inmate. It has to go through a third party, and that's most likely a corrections officer. So obviously, MCC, not the best place to be keeping people. We'll go back to MCC at some point because, boy, when I tell you that Ghislaine Maxwell did nothing but bitch about her time in jail, I wish that I could just reach down, grab her by the neck, and strangle her because I was so tired of reading all of these letters that she wrote where she was throwing a fit about how she was treated in jail. Now, one thing that I wanted to include, this is a little bit out of place, but it was a letter. It was a victim impact statement. And one of the victims' lawyers forwarded it to, I believe it was the U.S. Attorney's Office. And I want to read it for you guys because I think the victims get lost a lot in all of this. And I think it's really important to hear what this victim wanted to say and the influence and impact that this case had on her. All right. I appreciate the opportunity to again be heard by the court in this matter and once more request that Ghislaine Maxwell not be released prior to her trial. I write this not only on behalf of myself, but all of the other girls and young women who were victimized by Maxwell. Ghislaine Maxwell sexually abused me as a child, and the government has the responsibility to make sure that she stands trial for her crimes. I do not believe that will happen or that any of her victims will see justice if she is released on bail. She has lived a life of privilege, abusing her position of power to live beyond the rules. Fleeing the country in order to escape once more would fit with her long history of antisocial behavior. Drawing on my personal experience with Maxwell and what I have learned of how she has lived since that time, I believe that she is a psychopath. Her abuse of me and many other children and young women is evidence of her disregard for and violation of the rights of others. She has demonstrated a complete failure to accept responsibility in any way for her actions and demonstrated a complete lack of remorse for her central role in procuring victims for Epstein. She was both charming and manipulative with me during the grooming process, consistent with what many of her victims have described. She has frequently lied to others, including repeatedly lying about me and my family. Maxwell has for decades lived a parasitic lifestyle, relying on Epstein and others to fund her lavish existence. Maxwell has repeatedly demonstrated that her primary concern is her own welfare, and that she is willing to harm others if it benefits her. She is quite capable of doing so once more. She will not hesitate to leave the country, irrespective of whether others will be on the hook financially for her actions, because she lacks empathy and therefore simply does not care about hurting others. She would, in fact, be highly motivated to flee in order to reduce the possibility of continued imprisonment, the conditions of which she has continuously complained. Her actions over the last several years and choice to live in isolation for long periods suggest that being comfortable is more important to her than being connected. Even more concerning is if she is let out, she has the ability to once again abuse children, and the painful consequences of that type of trauma can last a lifetime. I implore the court to make sure that Ghislaine Maxwell does not escape justice by keeping her incarcerated until her trial. The sad part is, Maxwell does end up getting bail. At least that's my understanding of the documents. But one, I love that this victim says that Maxwell has a parasitic lifestyle, because she absolutely does. I think it's disheartening that this victim has to even petition the fact and express her fear that Maxwell could flee the country, because again, this doesn't just pertain to the US. It doesn't just pertain to Republicans and Democrats as much as the government wants us to think that. This is a global thing. People were, like, Epstein and his associates were outsourcing victims to other countries. We're talking London. We're talking Paris. Like, this is so beyond America. And if she goes out on bail, obviously this didn't happen because hindsight's 2020. We know that she's currently convicted. But at the time, there's a very real fear that she could go with these other associates, go out of the country, and then extradition processes get very difficult. And, I do think there's something to be said where she, one, has the benefit of being a woman, where historically women are not held as accountable as men are when it comes to crimes. And number two, the government hadn't at this point shown a lot of tenacity when it came to holding people like Epstein and Maxwell accountable. But again, I really wanted to read this because these words are directly from a victim. This, as well written as it is and as well articulated as it is, I don't think captures the amount of anxiety and fear that she probably felt when realizing that Maxwell could be out on bail. I can't imagine what that felt like. That has to be, like, if I were in her shoes, I would probably be quite scared. I would be very, very scared. And then there's also the very real fear that, okay, so let's say Maxwell gets out on bail, she leaves the country, and then she just hunkers down with somebody else, and the whole issue starts over again. So I really commend the victim for writing such an articulate statement, for putting her feelings out there and saying, hey, I don't believe this is acceptable. I do think it's shitty that the courts didn't listen. And as referenced in this letter, and we'll get into it, Maxwell did nothing but bitch about how much she hated her jail and prison conditions. And quite frankly, I don't think anybody should have given a fuck about it. But they did. They put a lot of effort into it emotionally, more than I think is necessary. All right. That's not an important image. This one is. Okay. So, like I said, Maxwell, bitching and moaning about just about everything. This email is from Maxwell's lawyers, where she had whined and complained about the temperatures of her cell, about how cold it was, how the humidity was too high. She was very upset about where she was being kept. She said she felt that she was being treated differently than other inmates, and a common theme throughout her letters and her attorney's letters is that, well, a murderer would be treated better than her. And yeah, that's exactly how it works in jail and prison. There is a hierarchy. So acting like this is news when it's been that way for decades is actually ridiculous. But let's just read what this has to say. This is from her lawyer. Good afternoon. I am informed that the New York City Department of Design and Construction will shut off water and heat to the MDC from 9 p.m. to 5 a.m. beginning tonight until 11:21. I am further informed that the MDC will give inmates 1 bottle of water and an extra blanket due to this disruption of services. I am requesting that my client, Ghislaine Maxwell, be moved from her present isolation cell with 2 exterior walls to an interior cell. Please explain why she cannot be moved to the cell in the day room area, where by court order she is permitted to review discovery from 7 a.m. to 8 p.m. Thank you. This is the reply. Thank you for including me on this email. I understand from my conversation with MDC legal counsel today that MDC staff is continuing to monitor temperatures throughout the facility, including in the area where Ms. Maxwell is housed. My understanding is that the temperature where Ms. Maxwell is housed remains within the limits prescribed by BOP, which is Bureau of Prisons, policy, and that the MDC does not expect this week's activities to affect the temperature in Ms. Maxwell's cell. That said, they will continue to monitor the temperature and take appropriate action if it falls below prescribed limits. As has previously been conveyed via letter from the government to defense counsel, dated October 8, 2020, the MDC's assessment continues to be that Ms. Maxwell's current cell is the most appropriate placement for Ms. Maxwell, both for her safety and the security of the institution. Finally, you have referenced a court order directing that certain steps be taken by the BOP. The only order of which I am aware is Judge Nathan's order dated blah 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 blah, which denied Ms. Maxwell's request for an order concerning the conditions of confinement. So basically, Maxwell has a consistent pattern of nitpicking and whining about her her cell, her confinement. And this shows, in my opinion, a fundamental disconnect between reality and her version of events. We know she's lived a very prominent, healthy, not healthy, but wealthy lifestyle. She has been used to that. She has been leeching off of people for decades because she doesn't want to live a lifestyle below the one that she has constructed for herself. So jail and prison are going to be very rough for her, which I think is a deserving punishment, and I have no sympathy or empathy for her, period. I think she should live in a freaking shithole for all I care, but there are standards with how you have to treat inmates, even people like Ghislaine Maxwell. But like I said, there is a disconnect between what reality is for her and this version of idyllic prison jail life that she has for herself. She is so used to getting what she wants all the time that she is sending letters through her attorneys, through her lawyers, to judges demanding that her conditions be resolved. She is given like 13 hours a day to sit in a day room and look through discovery, which is more than any other inmate in that facility. And she still has a way to complain. She can spend 13 hours a day outside of her cell, and she is still going to complain because she doesn't like the idea of being in prison, of being in jail. And frankly, she can cry a fucking river. I don't care. But this idea that if she complains enough, she'll get her way is so stupid. And it's almost funny because realistically, she has no sway in what goes on in jail and prison. None whatsoever. And the fact that she thinks she can rely on the behavior she has for a very long time, where if I whine and complain and I talk about how many people I know and how much wealth I have and how much money I have, eventually I'll get what I want. That doesn't happen here. And quite frankly, I'm very thankful for that because I probably would have punched a hole in my computer by now. So, again, obviously lots of redactions. This one was interesting, and I'm not going to talk on it too much, but it ties back into something that I said in the first episode or two of this series. So, this is discussing an interview. Again, I don't know by who, but there's a line down here that I want to talk about, which is that the victim stated, two other women also tell DOJ that Epstein specifically trafficked them to, quote, other men, and that there are cameras in the New York City house and others where he could watch people in bathrooms and elsewhere. I remember very specifically saying in the first episode, at the very least, that I believed Epstein was voyeuristic and he was an exhibitionist as well, where he liked watching and he liked being watched. This kind of corroborates that. He likes preying on people. I think that's pretty obvious. But the fact that he's putting cameras in places to specifically view girls, maybe even boys, in vulnerable states lends to that assessment that I made earlier on. Same with the fact that a lot of times there were other women involved in the sexual abuse that took place. Ghislaine Maxwell was often there as well, watching. So again, he's somebody who liked watching and liked being watched, and this corroborates that information. It also lends to the fact that there are other possibilities out there that are jarring and probably things that we don't want to think about, but the idea that he most likely taped what he was recording, because otherwise, what's the point? You get a live feed and then what? You don't have anything for like a week? Doesn't make a lot of sense. So there's a high possibility, but that there are films out there, actual videos of these victims in vulnerable positions, vulnerable states, and there's a chance that he was sending those around and selling them and using it as child pornography for his buddies. And that, to me, is incredibly disturbing. And I can only imagine how extensive that is. I don't know if that's been talked about in some of the newer file releases, but it wouldn't surprise me. I just think it's another point of concern. And it kind of reminds us how shitty it is for these victims, in the sense that if there are tapes out there, if it was shared, they're never really going to stop being victimized. Because these videos could be in like 17 different countries and they'll never know. And we will probably never know. And it could be circulating forever in emails, hard drives, other computers. It just sucks. It sucks so bad. And there's no way to scrub it off the internet. And again, this is a little bit of conjecture because I don't know for sure if that's the case. But also, given Epstein and his associates, I don't put it past him to have recorded things through those cameras and then distributed it. He's a businessman. He's going to make a profit. If he can have Joe Schmo pay him $50 for footage that he recorded of these children, I can see him doing that. And it's just sad. It is very sad. Okay. So this was in 2019. This ties back into Epstein's suicide. So this is kind of, I believe this was an interview of an associate or a supervisor at the MCC. And kind of her account on events. The paragraph that I want to pay close attention to is on page 3 of 3. Where the supervisor says she does not know the particular procedures or guidelines regarding an inmate who comes off suicide watch. She stated that usually that inmate is put with a cellmate, but she does not know if this is policy or just general practice. According to Blank, as an SOS, she wouldn't know if Epstein was supposed to have a cellmate. A decision such as an inmate needing a cellmate would be made at SHU meetings and or department head meetings. Blank doesn't know if Epstein had a cellmate that day. She was acting lieutenant. Blank advised that the count paperwork stays in control for 30 days. After 30 days, the paperwork is shredded. So, going back to the procedures that were supposed to be taking place when it came to Epstein and who was watching him, I believe, and I could be wrong because I read this a while ago, Epstein had a cellmate at one point. I'm pretty sure that his cellmate got moved at one point. Let me pause this and look this up really quick because I don't want to mislead you guys, so give me 1 sec. Okay, so there's a little bit of misinformation and argumentative narratives pertaining to the cellmate and his motive, but Epstein did at one point have a cellmate. There's some discrepancy on whether or not this cellmate tried to kill him or whether or not Epstein tried to hire the cellmate to kill him. None of that was proven. Again, the medical examiner ruled Epstein's death a suicide and not that it was homicide. But Epstein's cellmate was not present at the time of his death. So, there we go. Okay, moving on. We are back here. I have that email twice. I apologize. I should not have that email twice. Okay, cool. So, this is an email that I thought was particularly interesting because it talks about Epstein's behavior outside of just the sexual deviancy and the sexual predator that he is. So this comes from a reporter who says, I'm working on a story about one of Jeffrey Epstein's recent Virgin Islands-based charities, Gratitude America, which is interesting for a few reasons. Number one, it got most of its funding from a $10 million grant from a foundation controlled by Leon Black of Apollo in 2015. Again, if you've watched the earlier episodes in this series, you know that Leon Black had allegations made against him by victims, most of which were settled out of court. And there's pictures of Leon Black in a bath towel, buck naked, smoking a cigarette with a watch on at one of Epstein's residence. So there is a very lengthy and extensive connection between Epstein and Leon Black. There's supposed fraud schemes that went on between the two. I don't know a whole lot about that. It's a little bit above my pay grade. But again, just documentation that there is a connection there. Then we move on. Number 2, some of Gratitude's donations between 2016 and 2017 listed in its tax forms were never received by the named charities. So again, kind of lending to the fraud schemes of it all. But also, it's not surprising that this guy, Jeffrey Epstein, did not donate to charities because why would he give a shit? Like I said, he's a narcissistic man. I am a firm believer of this. Very, very narcissistic. High on the psychopathy charts, if not a psychopath at his core. if he can get away with it, he's going to get away with it. And the fact that nobody really noticed that none of this money went to the designated charities until, let's see, 2019? This is 4 years later, and the only reason this was brought up was because all the shit hitting the fan with Epstein kind of proves that this guy was not just a scumbag by being a child predator, but a scumbag in the sense that he was pocketing money that was supposed to be donated to charities to help other people. On top of that, this reporter alleges that Epstein attempted to use the charity to pay fines in the Virgin Islands. So he's having people donate him money on good faith, knowing damn well that he's never actually going to use that money to benefit anybody. Then it goes on to talk about specifically banks and the type of bank that Epstein used. Again, I don't know a whole lot about that, but this really kind of highlights the fact that Epstein was involved in quite a few different fraud schemes, a lot of which can't really go anywhere because he's dead now, unless you look at people like Leon Black, who at this point stepped down as CEO of the Apollo company. I will say that I don't know a whole lot about the psychology of fraud other than the fact that it's a sociopathic antisocial behavior. It's also psychopathic behavior in the sense that you are going to swindle people out of money that was supposed to be used for a good cause and then just put it in your own pocket. But I do think it's something that's worth bringing up, and the fact that, not only was he a child predator, he was taking money away from people who actually needed it and then was engaging in fraud schemes. So, this guy just gets worse and worse every time you read more about him, which thankfully you guys don't have to do, but I sure have to do because Jesus Christ, this shit sucks. Now, I will say it's quite interesting because in my line of work, the way frauds happen nowadays is it's predominantly online. It's through the phone, it's through the computer, it's through PayPal, Amazon, Apple, and through AI. But this seems like it was a lot of old school fraud in the sense it's like physical checks, physical banking statements, wire transfers, things like that. So it's a little bit interesting to see just how quickly fraud schemes have changed in the span of a decade. In 10 years, it has changed exponentially. It's actually quite impressive in a very scary kind of way, but just a fun fact. All right, moving on, we're going to talk about something that I have conflicted feelings on called the Epstein Victims Compensation Program. What we want to look at specifically is down here, which states that the program is governed by the following non-exclusive guiding principles. Number one, the program is purely voluntary, which is great. I don't think you should be able to force anybody into a compensation program. It does not affect any rights a claimant may have unless and until the claimant accepts the offered compensation and executes a release. A claimant may reject the offer of compensation and may stop participating in the program and withdraw the claim at any time prior to execution of the release. The program is independent and will in no way be administered, controlled, or overseen by the estate itself. The administrator is responsible for all decisions relating to the review, processing, and evaluation of individual claims submitted to the program. The administrator will have final, binding, and exclusive authority to determine claimant eligibility and the valuation of each eligible individual claim. Decisions of the administrator in any way by the estate or any other party or entity. There is no cap or limitation on the aggregate amount of funds available to compensate all eligible claimants or on the amount of compensation to be made to each individual claimant. Each individual claim will be evaluated separately by the administrator. The administrator will determine in her sole and exclusive discretion issues of eligibility and the amount of compensation, and the estate will pay all eligible claims based on the administrator's determination. All claimants will be treated with respect, dignity, and fairness without regard to race, color, sexual orientation, national origin, religion, gender, or disability. To ensure claims will be adjudicated fairly, the administrator will manage the process so that all claimants can equally access the program's claim process. The individuals with disabilities will be given the opportunity to effectively communicate their claim and to request special process accommodations. The program is available to all victims, survivors, regardless of where they were harmed, when they were harmed, where the claim is time barred by the applicable statute of limitations, and whether they have previously filed a lawsuit against or settled with Epstein and or the estate. The caveat here, and I don't know if I have it in the next photo, I believe I do, is some of the eligibility criteria. The persons eligible to participate in this program are individuals who allege they were sexually abused by Epstein. In addition, the following criteria apply. The claim of sexual abuse must be directed against Epstein. So if they were trying to direct anything against Ghislaine Maxwell, etc., wouldn't apply, which makes sense. This is specifically pertaining to Epstein. An individual whose claim is time barred by the applicable statute of limitations may participate in the program provided that other eligibility criteria are met. Again, kind of sucks because now you're limiting who in the victim pool actually gets to have any type of compensation if they want it. An individual who previously entered into a settlement agreement resolving a claim of sexual abuse against Epstein may participate in the program provided that other eligibility criteria are met. This is basically saying if you had a civil suit previously, you can still participate in this. An individual who allegedly assisted Epstein in procuring other victim survivors may participate in the program where there is a credible basis to determine that the individual acted under duress as a result of her own sexual abuse by Epstein, provided that other eligibility criteria are met. Now, this right here is interesting because this is like such a subjective rule to hold people by. Because, as I've discussed before, there are individuals who were, yes, victims, but wholeheartedly, without regret, without remorse, wanting to victimize other individuals. And there were others who, expressed remorse, who were upset by what they did, and who actually sought to make reparations for the actions that they took. Now, the problem here is going to be differentiating where people lie on that subjective criteria. And the problem or the concern that I would have with this is that some people are going to be barred from entering the compensation program when they shouldn't be. Because how do you prove duress? Especially, let's say, this happened in 1990? It started in 1994, okay? 15 years later. How do you prove what somebody's mental state was at the time that this was going on? So again, slightly problematic in my own opinion. Then we move on. If the claimant chooses to accept the offered compensation, the claimant must dismiss with prejudice any existing lawsuits, legal actions, or claims filed against the estate or related entities and or related individuals. The claimant must provide proof of such a dismissal along with or prior to the signed acceptance of the compensation determination offer letter and executed release in order to receive payment. Now, this is the catch-all. This is the caveat, because it's basically saying, if you partake in this and you agree to accept an amount that we have determined for you based on how much of a victim you were, you can no longer file any sort of legal proceedings against Epstein. You are now barred from it because you have been given your compensation for being sexually abused. And the interesting thing here, and the problem that I have with this, is number one, the government is saying in the non-prosecutorial agreement that Epstein was supposed to provide financial compensation anyways. So, why do we have the need for this? To bar them? Putting this clause in here, what's the point? We already have the non-prosecutorial agreement. We already have it saying that people are going to be paid out. So, why are we now limiting who can come forward and say, hey, I want to press legal actions against Epstein and his estate, when, in all reality, as far as the non-prosecutorial agreement goes, you could potentially prosecute Epstein in a different state outside of, New York. So if you were assaulted in New Jersey, because the non-prosecutorial agreement, as I learned, applies specifically to a handful of states, now you are saying that they wouldn't be allowed to do that if they were part of this fund, which is weird. I don't like that. I also just don't like the idea that people aren't allowed to pursue criminal charges against somebody because they were given a lump sum of money. It doesn't seem fair, because also, going back to the non-prosecutorial agreement, those were still criminal charges that were pressed that certain victims got to be included in, that others who may not have been included in that, they don't get the same satisfaction. So it just feels a little limiting. It feels a little weird. It feels like, hey, take this money, shut up, and go away. And I'm not a fan of that. I think that if the government's going to say people are entitled to compensation, they should not have to register under this claimant agreement and say, yeah, I'm going to give my rights away for, prosecuting Epstein and his estate further. I don't think that that's fair. That's my personal opinion. You can disagree. I'm not super familiar with how all of that works. That's just how I feel about it. Hopefully that made a little bit of sense. I'm not super in depth on like finances and how that works. I don't know if there's different legal restrictions that would keep them from double dipping, but I also don't see it as double dipping when the government outright said, yeah, these people should be compensated, to then force them to register. Well, they're not forcing them, but then to ask them to register for something else entirely. Like, I guess my issue, to kind of make it clear, is why do we have two separate avenues to achieve the same goal? Why do we have the government saying, yeah, you'll get financial compensation from the estate, and then you also have this other program that people can register for saying, yeah, we'll give you financial compensation, but you don't get the benefit of like prosecution? I don't understand the purpose of having both of those things in place. Now, if one was in tandem with the other and was contingent on the non-prosecutorial agreement, I would get it, but I think it just muddies the water and it makes things difficult for the victims. And they've already been through a lot, so why do we have to make things harder for them? Okay, so the important part of this upcoming email is right here at the bottom. So this is a reporter asking somebody in the U.S. Attorney's Office in New York about good old Prince Andrew. So they asked some questions about Ghislaine Maxwell, because we fucking hate her and we don't really want to talk about her a whole lot until we have to, because there's stuff pertaining to her later. We're going to look at number 6 here on the email, which says, is the investigation into Maxwell and Epstein's network still going on? If so, does Prince Andrew remain a person of interest? Have U.S. prosecutors managed to get a statement from him yet, or are there any arrangements in the pipeline to do so? Well, that's a great question. Great question. So there's actually a pretty lengthy email exchange, and I can't remember if I include a screenshot of it. It's a little bit funny because it's just so sad. But it's Prince Andrew's, who, by the way, is the Duke of York or whatever the fuck that means. I wasn't aware of what that meant. I had to Google it. They have like kings, queens, dukes, peasants. It's weird over there. He and his lawyers were like, oh, I will provide a written statement. And the U.S. was like, well, can you just do like an interview in person? And he was like, no, absolutely not. And they were like, can we record it? And he's like, no, absolutely not. I will give you only a written statement. And the U.S. was like, yeah, dude, that's not gonna work. We don't want just like a 6-page written statement. We want to interview you. We want it videotaped. We want it for the record, because realistically, if he's giving a written statement, he gets to control the narrative. He gets to control the flow of what he's saying and the information he's giving. Whereas if you are being questioned or interrogated, the questioners and the interrogators get to kind of run that show and get to really uncover things that he himself may not want to admit, which he can kind of hide in a written statement. And he goes back and forth and back and forth. And the defense, Prince Andrew's defense, keeps saying over and over again, as I've already stated, he is more than willing to cooperate, but he will not provide. And I was just like, holy shit, guys, get it together. There is a statement by Prince Andrew himself that we will take a look at down here. Statement by His Royal Highness, the Duke of York, KG. I don't really know what KG stands for, but anyways, it has become clear to me over the last few days that the circumstances relating to my former association with Jeffrey Epstein has become a major disruption to my family's work and the valuable work going on in the many organizations and charities that I am proud to support. Like the charities Epstein supposedly supported and then pocketed the money for so that he could pay bills in the Virgin Islands? Is that what we're talking about, Andrew? Anywho, therefore I have asked Her Majesty if I may step back from public duties for the foreseeable future, and she has given her permission. Oh, you mean to hide from scrutiny and finger-pointing because you probably did something really bad, but you're kind of painting it in a way where you're doing a service to the public? Sounds fishy. I continue to unequivocally regret my ill-judged association with Jeffrey Epstein. That's a nice way of putting it. His suicide has left many unanswered questions, particularly for his victims, and I deeply sympathize with everyone who has been affected and wants some form of closure. I can only hope that, in time, they will be able to rebuild their lives. And then the highlighted part. Of course, I am willing to help any appropriate law enforcement agency with their investigations if required. Now, what I like to call that last highlighted sentence is a contingent statement. If you look at the last two words, it says, if required. That's contingent, okay? He's not saying, oh, I'm going to go out of my way to help people. I'm going to go out of my way to assist in the investigation. Hey, US, you guys talk to my lawyers? You want an in-person interview? You want it recorded? Hell yeah, I'll do it. No, I only want to do a written statement so that I control everything that's going on here, and I have privilege in the UK because I'm a prince, but in America, nobody gives a fuck. And then also, I will only be helping if required. And what that means is either you're going to extradite my ass to the US or you're going to subpoena me. And basically he's saying, well, if you twist my arm enough, if you really dislocate my shoulder, I guess I will help you. So that's the quiet part out loud. The way this is written is like, oh, I'm ashamed, blah, 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 blah. I don't really want to be in the public eye. The queen gave me her permission to just not be an embarrassment to society. I regret my association with Epstein. I'll do anything to help, but also I'm only going to do that if you do extreme measures and force me to participate in an investigation. That's really what that means. So, yeah. Also, I'm pretty sure there's quite a few pictures out there of Prince Andrew doing some very unsavory things. So, Prince Andrew, I can read through your lies. I can read through your statements. You might be able to fool other people, but those last two words of if required say absolutely everything I need to know about your willingness to actually help people and how you actually don't give a shit about victims because, well, there's quite a few pictures out there of you doing things that you probably shouldn't be doing with children. You sick fuck. Here we have a subpoena to the Mar-a-Lago Club in Palm Beach, Florida. Where have we heard about the Mar-a-Lago Club before? Oh yeah, that's Trump's little shindig, right? Oh yeah, where did we hear about the Mar-a-Lago Club before in a previous episode? Oh, that's right, where one of the victims was specifically recruited from Mar-a-Lago because, oh yeah, that's right, Ghislaine Maxwell and others approached her while they were leaving Mar-a-Lago, and they said, hey, you look really hot and attractive, maybe you should come work for Epstein. Oh yeah, that's a little suspicious, that's a little weird, let's keep an eye on that, guys, let's keep an eye on that. Okay, this next little bit, I will say, is a little bit funny. It shouldn't be, but it definitely is. And you'll see why. But this was an article that was included in the files, and I'm going to read it to you. Okay? And then we're going to talk about it. Billionaire sex offender Jeffrey Epstein ducked a modeling agency's lawsuit Wednesday when a Florida appeals court ruled the business had failed to properly serve him with the complaint at his primary residence on a private island in the Caribbean. Hey, guess what modeling agency it was? Oh, don't worry, we'll find out. Florida's 3rd District Court of Appeals said service of this complaint by Miami-based MC2 Model and Talent LLC and its owner Jean-Luc Brunel on an office supervisor at Epstein's U.S. Virgin Islands business address did not comply with the requirements under Florida law and that the suit should be dismissed without prejudice, meaning it could be refiled. The appeals court agreed with Epstein, who had argued that Brunel and MC2 never attempted to serve him at his primary residence, a private island called Little St. James in the U.S. Virgin Islands. Quote, Brunel and MC2 attempt to excuse strict compliance by arguing that the legislature could not have contemplated a lifestyle like Epstein's, end quote, the 3rd District said. But Brunel and MC2 never tried to serve Epstein as his place of abode. Epstein argued that service of process takes place routinely on private property and that his private island, is accessible by boat, has a large dock, and is easily located on any map. Nothing would have prevented a process server from tying up to the dock and asking for him, Epstein said. Brunel and MC2 sued Epstein in January 2015 in Miami, claiming the notoriety and bad publicity stemming from sexual assault and prostitution charges against Epstein cost the agency business. Brunel has been linked to Epstein and has been accused by at least one victim of supplying Epstein with underage girls. Epstein pled guilty in 2007 to felony charges involving solicitation of prostitution and procurement of minors for prostitution. He served 13 months in prison and is a registered sex offender. Brunel tried to serve Epstein at his residential address in New York, but Epstein successfully moved to quash service, according to the opinion. Brunel then tried the Virgin Islands business address, which the trial court deemed acceptable in September 2018. But the 3rd District said that in order for substitute service to be acceptable under Florida law, it must be made on an individual doing business as a sole proprietorship. The Virgin Islands business is not a sole proprietorship owned by Epstein, according to the appeals court. In February, a Florida federal judge ruled that prosecutors, including then U.S. Attorney and current Labor Secretary Alexander Acosta, violated the Crimes Victims' Rights Act when they signed a non-prosecution agreement with Epstein without notifying the victims. Let's break that down, shall we? Because not only is it absolutely ridiculous, I can see right through the bullshit. So, we have Brunel, Jean-Luc, who I've talked about quite a bit before. There's a plethora of pictures of him on Epstein Island, hanging out with Epstein. He practically fucking lived there, if we're being honest. And what do you know? He gets convicted of, having sex with children, prostitution, and he goes to prison in Paris, and then what does he do? Oh yeah, he kills himself. That sounds really familiar. Wonder where I've heard that before. Yeah, so this whole bullshit that he didn't know where to serve Epstein in this fake little lawsuit to save face, I don't buy it. I don't buy it for a second, because he knew Epstein like the back of his hand. They were best friends. They were pedophile buddies. He spent all of his time, like literally all of the pictures of Jean-Luc are on the Virgin Islands. He did spend some time at the ranch in New Mexico and elsewhere, but predominantly he spent time on Little St. James. So Jean-Luc knows where that's at. He knows how to get there. He knows that that's Epstein's primary residence, because that's where most of this criminal activity took place, because it was on a private island. So this whole, well, I didn't know where to serve it, blah, 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 blah. This investigation is looking bad for Brunel. It's all to save face. It's all to save face. He wasn't actually going to serve Epstein with anything. There was no reason for him to do it. Why would you do that? Why would you bite the hand that feeds you? Epstein is bringing children for you to rape, and you're gonna sue him? That doesn't make any sense. There's no reason for him to do that. It's all to save face. It's a ploy to say, oh, well, if I sue him, then I'm therefore not associated with him. And it's bullshit. And the fact that anybody believed it was a legit lawsuit is kind of crazy. I know I sound like a conspiracy theorist, but I mean, think about it, right? Like, this guy, like I said, basically lived on Little St. James Island, and you expect me to believe that he wouldn't know how to properly sue Epstein, who he's had multiple business relations with, because again, Epstein had access to the modeling agency at which Jean-Luc ran, okay? So I don't buy it for a second. I do think this article is very important because, again, it gives us insight into the minds of the people that worked with Epstein and how they save face. It's deny, 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 blatant association, deny, 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 until you are caught and you can't deny it anymore, and therefore you end up in jail and prison. Because Ghislaine Maxwell did the exact same thing. That's why she perjured herself on the stand. She denied, 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 denied. There was photographic evidence. There was clear indication that she and Epstein were associated, affiliated in a criminal scheme to rape children and traffic children, and yet she still denied. Because what else can you do, right? You can, I mean, when you think about, like, rape and child predators, it's probably the only crime that doesn't have an actual excuse to it. Murder, you have a self-defense motive, right? You have different tiers of murder where some people, it's a crime of passion. You get so mad, you kill somebody, therefore you don't have first-degree murder. You have second-degree murder or manslaughter. Stealing, right? Oh, well, they were homeless and they stole because they didn't have any food. Still illegal, but there's a justification for that. You can't spin child sex trafficking or rape in any way that is going to make it palatable to the public or to any court system. At least it shouldn't. So you have two options, which is, yeah, I was there and I knew it was going on, or I have to deny it because that's the only thing a logical person can do. You cannot sit there and say, well, I mean, I kind of maybe dipped my toe in the water and like half raped a child. That doesn't work. That doesn't fly. Your only option is to deny. And we see that with Jean-Luc, where he has to deny it. He has to put some stupid fake lawsuit together to throw freaking smoke out the other way and say, oh, look over here, guys, there's a fire over here. I had absolutely nothing to do with it. And then lo and behold, he very much did, was convicted, and then ended up killing himself. Okay. All right. So again, this is the email chain that I talked about. I did grab a screenshot of it. I'm very thankful for it. But this is between the Duke of York's defense and the U.S. attorney. So, Prince Andrew's defense says, Dear Blank, I believe my response is clear. The Duke of York will provide a witness statement and will agree, following the provisions of that witness statement, to a voluntary written interview wherein he will answer any and all relevant questions of him as a witness in writing about the full range of topics relevant to your ongoing investigation, including events not covered by the currently pending indictment against Ghislaine Maxwell. If you want to ask any questions in person or via video rather than in writing, I'm sure the Duke will be willing to receive your questions in that format before providing written answers. So again, he's saying, I will write everything down, but I will not do anything in person and I will not record myself. U.S. replies, Dear Gary, thank you for your email of September 16, 2020. We understand that your client has declined to sit for a voluntary interview and provide oral answers in real time to our office. Because the written statement you propose to provide will not assist our investigation, we intend to move forward with our MLA request, seeking a compelled interview of your client. Accordingly, we plan to inform the UKCA that the parties are not able to reach agreement on a voluntary interview and that a voluntary interview will not occur. Okay? Keep that in mind, remember that, because then we go back to this letter. Of course, I am willing to help any appropriate law enforcement agency with their investigations if required. The quiet part is being said out loud, if required. He is not going to do shit unless he is forced to do it. And the way that his attorneys discuss things in that email proves that he is going to do it his way or the highway, and the U.S. basically says, okay, bet, then we are going to compel you to do an interview, which is exactly what he says will happen here, except he's pretending to be helpful, and he's pretending to actually give a shit. Here we get into documents pertaining to questions that Ghislaine Maxwell perjured herself on, and I feel like everybody kind of knows what perjury is, but in case you don't, basically when you go into court, whether you're a witness, prosecution, defense, they ask you, like, are you going to tell everything to the truth? You can swear on the Bible, the Quran, Torah, and you basically say, yes, I'm going to tell the truth, and it's basically like, okay, cool, you understand that if you don't tell the truth, you can be prosecuted. And everybody's like, yeah. Ghislaine Maxwell was like, yeah, dude, I promise I'll tell the truth, and then she very much didn't. So she was asked when she met an individual, and she replied, I have no idea when I met her. Do you know how old she was when you met her? I have no idea how old she was when I met her. Is it possible she was 13 years old when you first met her? And then the attorney says, object to the Foreman Foundation. He'll say that to just about every question. Blank was Jeffrey's friend, and her mother was Jeffrey's friend. So Blank may have been in that house when Jeffrey was in the house. I have no idea how old she was. I'm going to read all of this, and then again, I'm going to pick at some of the language, because you can tell a lot about somebody's intentions based on the language that they use. Even if they are trying to be slick with things, they will say stuff in their statements that give away what they're actually thinking, what their emotions are pertaining to the matter, and the underlying psychology of their answers. So there can still be a lot to gain even from written statements, but you just don't have body language and things like that. Okay. I understand she was with her mother. I'm asking if Blank was 13 years old when you first met her. I have no idea. Was she under 18 when you first met her? I have no idea how old she was when I first met her. Did she look like a child when you first met her? I don't remember what she looked like at the time she was in the house. How many years have you known her? I can only recall the last time I saw her. How many teenagers did he have that were professional masseuses that worked in his home? How many? First of all, I am not aware of teenagers who worked in his home. So let's pick apart some of this language. Where is it? Blah, 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 blah. Okay. So Maxwell is asked, is it possible she was 13 years old when you first met her? The answer is blank was Jeffrey's friend, and her mother was Jeffrey's friend. So blank may have been in the house when Jeffrey was in the house. I have no idea how old she was. So that first statement, okay, is very important. Because what we see with predators, what we see with people who are in interrogations and questions is a lot of them will do minimization techniques. They will try to minimize the severity of something. So she's not saying right off the bat, I don't know how old this child was. She's providing a bunch of unnecessary context. And what is that context? Well, the context is saying, well, the guardians of this child were friends with Epstein. And if they were there, then she would have been there. Therefore, it's not weird that she was in the house because her parents were there. What this does is basically say, well, if her parents were there and she was 13, it's not like she was there by herself as a 13-year-old, and it's not like she wasn't without parental supervision. Therefore, her being 13 is irrelevant. Now, that's not the question that was actually asked. But after providing this contextual statement, she says, I have no idea how old she was. But with the contextual statement beforehand, that directly negates her, I have no idea how old she was. Because she does. That's why she's providing the context that legal guardians were present, because she does know that this person was 13 years old, maybe even 14 years old, and that if that child had been there by themselves without guardians present, it would have been really weird and it would have been really inappropriate. So what does she do? She sandwiches context before it. The questioner does a very good job of redirecting her and saying, yeah, I get that, dude. I know that she was with her mother. I'm not stupid. I'm specifically asking you if she was 13 years old when she first met you. And this is eliminating Maxwell's ability to provide that minimizing contextualized statement, and she's just forced to say, I have no idea. So, knowing that Maxwell's not going to give up that this child was 13 years old, the prosecutor or the questioner, I'm not exactly sure what their role is, they're going to switch it a little bit. She's going to say, okay, we're not going to focus on this kid being specifically 13 years old. We're going to be a little more generalized. We're going to say, well, was she under 18 when you first met her? And the answer is, I have no idea how old she was when I first met her. So why does the prosecutor switch to the question of, was she under 18 when you first met her? Because, unfortunately, there is a mindset where once you reach a certain age, maybe like 16, 17, and we see it in this case specifically, there's a little more autonomy and there's less of a concern when it comes to children that are 16 and 17 who are victimized, because it's, well, they're almost 18, they're almost to adulthood, but they're not yet, right? A logical person knows a 16-year-old is not anywhere near 18. But when you look at the numbers at face value, what's going to be more egregious, 13 or 16? So the questioner, the prosecutor, is saying, okay, well, she's not going to concede to the fact that this person was 13 because it just sounds that bad and shitty, and she's already tried to minimize this before. Why don't we just say if they were under 18? Because that leaves it ambiguous, it leaves it open. They could be 17 and a half. That's not as bad as a 13-year-old, right? But Maxwell's not going to give it up. So then, they ask her, did she look like a child when you first met her? Because at this point, Maxwell's not going to give anything about age, all right? She's already said, I'm not telling you shit about this kid being 13. I'm not going to tell you shit about them being under 18. Okay, fair enough. If you don't know how old they were, did they at least look like a child? And then you say, I don't remember what she looked like at the time she was in the house. But you know she was there, and you know what her parents were there, but you don't remember what this one very distinct individual looked like. Now, most people who you interact with would be able to tell whether somebody's 13 or closer to 17. And most people would say you're going to remember the individuals that you invite into your house, because it's a very private space. And so, again, Maxwell is shifting away from the question. I don't remember what she looked like at the time she was in the house. Again, she's providing a little bit of context. She's saying she doesn't remember what this child looked like at that specific window of time. Not that she doesn't remember what the child looks like at period. She could have just said, I don't remember what the kid looks like. But she adds the statement at the time she was in the house. Meaning in that particular incident, she conveniently can't recall whether this child looked like a child or not. So again, she's kind of answering the question without answering the question and adding context there that she may not even realize she's adding, which implies, yeah, I know what this kid looks like. I know exactly who you're talking about in all of these other contexts, but I'm going to tell you that I specifically don't remember at this one point and moment in time. I think I have other statements of hers. Yep, okay. Let's look at these. Again, I'll read them and then we'll talk about them. Did Jeffrey Epstein have a scheme to recruit underage girls for sexual massages? If you know. I don't know what you were talking about. Can you list for me all the girls that you have met and brought to Jeffrey Epstein's house that were under the age of 18? I could only recall my family members that were there, and I could not make a list of anyone else because that list, it never happened that I can think of. And then they go on. List all the people under the age 16 of, the numbers confused me. List all the people under the age of 18 that you interacted with at any of Jeffrey's properties. I'm not aware of anybody that I interacted with, other than obviously blank, who was 17 at this point. And then, did Mr. Epstein ever ask you to attempt to obtain or secure people to give him massages that were not professional masseuses? No. So, we're going to start down here. This is a deposition from 2016. When she answers no, that's the first straight answer she's given out of all of this material where she's perjured herself. Outliers like that are very important because she's not providing context. She's actually being very definite in her answer, which is unusual because, as we can see in the way that she normally answers questions, that's not always the case. So, when we have the question, did Jeffrey Epstein have a scheme to recruit underage girls for sexual massages? Maxwell replies, I don't know what you're talking about. Again, very dismissive. She's not using, no. She's saying, I don't know what you are talking about. Obviously, we know that she does know. And obviously, she is perjuring herself. I don't quite know how to say that word. But what this tells me, okay? What this tells me is, one, she's not going to give an inch, because if she gives an inch, the prosecution and the questioner is going to take a mile with it. But the specific phrasing, I don't know what you are talking about, indicates that she's not specifically addressing, like, any of the question. If she says, I don't know what you're talking about, that could be in reference to the scheme of recruiting underage girls, the reference to sexual massages, the fact that the girls were underage. Instead of saying no, which is putting this blanket statement to rest, she's saying, I don't know what you're talking about, and that could apply to any part of this. So if the questioner changed the phrase, did Jeffrey Epstein have a scheme to recruit girls for sexual massages, and you remove the underage part, that may change the answer. Or it could not, but the I don't know what you were talking about could apply to, she's not lying because you used the word underage, and she isn't aware of any scheme pertaining to underage girls. But if you had asked her, did Jeffrey Epstein have a scheme to recruit girls for sexual massages, then she would have answered honestly. So again, it kind of, it builds in a little bit of plausible deniability. Then we have her giving more useless context when asked, can you list for me all the girls that you have met and brought to Jeffrey Epstein's house that were under the age of 18? Maxwell replies, I can only recall my family members that were there, and I could not make a list of anyone else because that list, it never happened that I can think of. First of all, she's doing the minimization. Well, yeah, it would be natural for there to be kids under 18 that are her family members that are going over to Jeffrey Epstein's. Like, their business partners, their romantic partners. All of that makes sense. It wouldn't be weird for them to be there. So she's also, again, building implausible deniability where it's like, well, she's not lying because there were kids there that were under 18, but they weren't involved in any of the schemes going on. Then she says, it never happened that I can think of. When people say I can think of, a lot of that time it's in context to a specific question at that moment. So if somebody said, hey, Emily, I want you to give me a specific example of a time when you did X, Y, and Z. Being put on the spot, there may be an answer where I say, there's not a time when I can think of that I did X, Y, and Z. Doesn't mean it didn't happen. In fact, the statement implies that at some point it did happen. I just can't think of it at the moment. So when she says it never happened that I can think of, she's saying in this particular moment, there is not a time in which that occurred that I can think of. However, that doesn't mean it didn't happen. Hopefully that makes sense. But again, just pointing out that you can tell a lot about a person based on the way they answer things and the type of words that they use. It is all very, very important. And that's why I like seeing all of these written documents, because it shows sometimes the quiet parts are the most important parts. Okay, now we're going to talk about something that kind of rubbed me the wrong way. But we're going to read quite a bit here, so hold on to your butts, okay? So this is in pertaining to the Criminal Victims' Rights Act. And this was to do with petitioners who were basically saying, you guys screwed us over, we want compensation for that. And the court initially responded in 2013, and the sentiment of the court was basically, fuck you guys, you don't have a leg to stand on, your rights were not violated. I disagree with that. That is my personal opinion, and as you will see in about 2019, when the government retouches on this petition, they're a little more gentle in how they say things. So, in these proceedings, the only identified legal relief that petitioners have sought pursuant to the CVRA is the setting aside of the non-prosecution agreement that was entered into between Jeffrey Epstein and the U.S. Attorney's Office for the Southern District of Florida. The relief petitioners seek is to invalidate the non-prosecution agreement. But even assuming that petitioners' rights under the CVRA were violated when Epstein and the USA attorney entered into the non-prosecution agreement, constitutional due process guarantees do not allow either the non-prosecution agreement, which by its terms induced Epstein to enter a plea that was guilty, to state criminal charges and serve an 18-month sentence of state incarceration, or the governmental obligations undertaken therein to be set aside. Basically saying, well, for argument's sake, if your rights were violated, which we definitely don't think they were, we can't take the non-prosecution agreement away because the U.S. agreed to it, and it's just kind of tough shit at this point. And then they go on to say, indeed, if this court were somehow to set aside the non-prosecution agreement on the authority of the CVRA, and even if after... I clicked on that, weird. And even if after consultation with petitioners, the United States determined that it would be proper and desirable to institute a criminal prosecution in the Southern District of Florida against Epstein on the criminal charges contemplated in the non-prosecution agreement, the United States would still be constitutionally required to adhere to the negotiated terms of the non-prosecution agreement. Basically saying, even if we were to take away the non-prosecution agreement, it wouldn't matter because we would still legally be required to uphold what was originally discussed. They go on to talk about due process. This is a little bit of a repeat, so we'll click to the next one. If it'll load. There we go. So again, it says, in these proceedings, the petitioners have sought to set aside the non-prosecution agreement pertaining to the possible filing of federal criminal charges against Epstein and the potential disposition of any such charges. Goes on to say that the petitioners claim they were denied their rights under the CVRA because they did not receive consultation with the attorney for the government regarding the possible disposition of the charges. Notwithstanding the non-prosecution agreement, petitioners are and have been free to confer with attorneys for the government about the investigation and potential prosecution of Epstein. At least one attorney for the government had spoken to petitioners about the offenses committed against them by Epstein prior to the signing of the non-prosecution agreement. Basically, what this guy is saying, well, you've always been allowed to confer with lawyers. It's kind of your fault that you didn't. And I think that's really unfair because realistically, how many people in America would know how to operate a situation like this and know to talk to U.S. attorneys who, by the way, as I discussed previously, stated that it was not their job to notify victims, when it very much was, and they just didn't fucking do it. So, in what universe is that an open line of communication between the U.S. Attorney's Office and victims. In what universe is that them having the right to confer with counsel? Oh, well, it could have been any counsel. It doesn't matter. The people handling the case were U.S. attorneys. It wasn't like freaking Joe Schmo who worked in Florida. This is the head honchos of the legal system in America. They go on to say, petitioners are free to contact the United States Attorney's Office in those districts and seek to confer with government attorneys in those offices about investigating and potentially prosecuting Epstein based on the alleged federal crimes committed against them. Petitioners nonetheless have appeared to contend throughout these proceedings that the many opportunities that they have been given to consult with the attorneys for the government about Epstein's offenses and the potential charges against Epstein, opportunities which continue to be available to petitioners, are not meaningful under the CVRA due to the existence of the non-prosecution agreement, which I happen to agree with. The part that rubs me the wrong way about all of this is the language that is used to refer to what the victims want and how passive aggressive it is. So, when he's saying that they can talk to other districts, this is what he means. And this is where I mentioned earlier that I learned something new about the non-prosecutorial agreement. Basically, the agreement says, prosecution in this district pertaining to the Southern District of Florida for these offenses shall be deferred in favor of prosecution by the state of Florida, provided that Epstein abides by the following conditions and the requirements of this agreement set forth below. And that after timely fulfilling all the terms and conditions of the agreement, no prosecution for the offenses set out on pages 1 and 2 of this agreement, nor any other offenses that have been the subject of the joint investigation by the Federal Bureau of Investigation and the United States Attorney's Office, nor any offenses that arose from the federal grand jury investigation will be instituted in this district, and the charges against Epstein, if any, will be dismissed. So the non-prosecution agreement, as shitty as it is, only applies to the District of Florida. The problem with that, and the problem with the judge and his tone and his ruling, is that not every victim was victimized outside of Florida. He's basically saying, well, if you were also victimized in New Mexico or London or New York, go press charges over there. It's not that big of a deal. When a large section of where the abuse took place was in Florida, and many of the victims were only victimized in Florida, so they can't go press charges anywhere else because they weren't victimized anywhere else. So giving them the middle finger and saying, well, you've always been allowed to do this is not freaking helpful. It is not helpful at all. And frankly, it's such a dick move, and it's the court basically saying, cry me a river about it. The U.S. attorney did what he was going to do. There's nothing you can do about it. And the sad reality is that there really is nothing they can do about it because it's legally binding. You can't undo it. But we also have to remember that the U.S. attorney himself said in a deposition in grand jury that they intentionally did not notify the victims because they were just going to have somebody else do it and assumed it was somebody else's job. So then we have a statement in 2019 where the same petitioners bring up the problem, and the judge replies, and he's much nicer, but this is their accommodation for what happened. These are the following remedies. Number 1, the Department of Justice will designate a representative to meet with petitioners and any other Epstein victim who wishes to participate to discuss the government's decision to resolve the Epstein case and engage in an open dialogue about that decision. That should have been done in the first place. This should not be something, we're going to do this after the fact so that you can see where we were coming from. Now that you can't change it and there's nothing that can be done about it, we'll keep you in the loop and let you know why that decision was made. That should have been a discussion that was happening with the victims from the very beginning, and it wasn't. And that is a shame on the U.S. government. Number 2, the government will participate in a public court proceeding presided over by this court in which the petitioners and any other Epstein victim who wishes to participate can make a victim impact statement. That hearing would be handled in a manner similar to the way the court would handle victim impact statements in the context of a criminal sentencing. Great! This would have been fantastic if the victims were notified about the prosecution agreement and allowed to testify in court at sentencing when that agreement went into place. I'm glad that they got to have an opportunity to talk about the damage that was done to them and able to express that and get that out there. But it does not hold the same weight and it does not have the same impact doing it 12 years later. It doesn't. There's no... Yes, they got to get their voices heard and they got to get it out there. But it would have meant so much more to them if the U.S. attorneys actually heard what they had to say, actually let them express what they wanted to say in court before a judge, before the prosecution agreement went in there. After the fact, it's not the same, and you deprived them of that. And doing this in retrospect, while it's great in theory, it's really shitty. Number 3, all criminal prosecutors in the United States Attorney's Office for the Southern District of Florida will undergo additional training on the CVRA, victims' rights and victim assistance issues, to be completed no later than 1 year from the date of the court's final order in this case. So congratulations. You're awarding them 2 things that they should have been allowed to do from the very beginning, and then saying, you know what, we'll just put extra training in. We'll make sure the HR department really pushes that out there. While the tone of this is much more respectful and they're actually engaging in a dialogue, I think that it's just as disrespectful in a way, because it's a joke and they really didn't do anything. And then in the same document, the same ruling, there's something I really want to talk about. It says, if, however, the ombudsman finds that the DOJ employee willfully or wantonly violated a crime victim's rights, the ombudsman shall recommend, quote, a range of disciplinary actions. Disciplinary actions means those sanctions provided under the Department of Justice Human Resources order, which include written reprimands, suspensions, reductions in grade or pay, removals, and furloughs for 30 days or less. Again, we have Alex Acosta, the U.S. attorney, saying that he willfully and knowingly did not notify victims about what was going on because he said that it was not their job. And this is a guy that is in charge of everything. And let me remind you, the key word here is an employee willfully or wantonly violated a crime victim's rights. Alex Acosta willfully did that. Where's his punishment? Where's his reprimand? Because as far as I'm concerned, he's still in the government somewhere, and he was allowed to keep practicing law. In fact, he was trying to get employed on Epstein's defense team at the time that this case was going on. I would like to know. I very much would like to know what happened there. Then they go on to say, conclusion. Regardless of what the CVRA required the government to do in this matter, the victims are right to expect better from their Justice Department. You're damn right. The government's commitment in the decades since this action was filed to combat human trafficking and child exploitation and protect victims of such offenses underscores that its conduct in this matter, no matter how well-intentioned, fell short of the government's dedication to serve victims to the best of its ability. I agree. While the court cannot unwind the past, the remedies proposed by the government would give the victims a meaningful opportunity to have their voices heard and to understand, if not accept, the decisions made in this matter. Again, that doesn't fucking mean anything. Petitioners' requested remedies, on the other hand, run afoul of the remedial scheme contemplated by the CVRA, are contrary to law, and may cause unintended harm to the victims, whose interests are also protected by the CVRA, because, again, they wanted to refund the non-prosecutorial agreement, and they were like, yeah, we can't do that. So, here you go. Here's your remedies. Stuff that you should have been allowed to do from the very beginning, but you weren't allowed to, but we're going to make it sound like a really good thing now. Also, the government doesn't give a shit about human trafficking and child exploitation anymore. If you watched the Pam Bondi hearing, you'll know that that woman just sat there and talked about the Dow the whole time and said that people had Trump derangement syndrome instead of answering a single fucking question. And let me remind you, Pam Bondi was best buddies with Alex Acosta during this whole process. So we really know how the government actually feels about all of this. Next, we're going to go to an indictment that discusses Maxwell's behavior. And I think it's important because it is called the Epstein Files, and there is a lot of focus on Epstein, which I think is important. I think it's appropriate. However, Maxwell was also deeply involved and deeply integrated, and her abuse is often unrecognized and underscored. And there were people that were equally victimized by Maxwell as they were by Epstein, and I don't think she should get away scot-free without being villainized just as much as Epstein, because and it pisses me off, there is an argument in some of these documents from her lawyers that say, paparazzi killed Princess Diana, and all of this paparazzi following her around is a danger. And to that I say, how dare you compare Ghislaine Maxwell to the People's Princess? Ghislaine Maxwell is the wet fart of America. And I'm going to make it very clear what type of person she is, because she is also a raging scumbag. Let's begin. Maxwell interacted with minor victim 2 on at least one occasion in or about 1996 at Epstein's residence in New Mexico when minor victim 2 was under the age of 18. Minor victim 2 had flown into New Mexico from out of state at Epstein's invitation for the purpose of being groomed for and or subjected to acts of sexual abuse. Maxwell knew that minor victim 2 was under the age of 18 at the time. While in New Mexico, Maxwell and Epstein took minor victim 2 to a movie, and Maxwell took minor victim 2 shopping. Maxwell also discussed minor victim 2's school, classes, and family with minor victim 2. In New Mexico, Maxwell began her efforts to groom minor victim 2 for abuse by Epstein by, among other things, providing an unsolicited massage to minor victim 2, during which minor victim 2 was topless. Maxwell also encouraged minor victim 2 to massage Epstein. Maxwell groomed and befriended minor victim 3 in London, again, outside the U.S., between approximately 1994 and 1995, including during a period of time in which Maxwell knew that minor victim 3 was under the age of 18. Again, she groomed them by discussing their friends and family and school. I swear I had more of those in there. I don't know where the rest of that went. Hang on. Nope, we already read that. Yeah. Okay. That circles back. So, let's not forget that when it came to the grooming process, that wasn't really Epstein doing that. That was Maxwell. And that is, it's been documented, and I don't know if I have screenshots of it, but she would get naked in the room with these children so that they were comfortable getting naked with Epstein. She would encourage these children to provide massages to Epstein, to get naked for Epstein. She herself would engage in three-way sexual acts with children and Epstein. She is filthy. She is disgusting. She is scum of the earth. The unfortunate thing is that her involvement and her participation in all of this is not documented to the point that Epstein's is. And I think there's a reason for that, and that is because as far as the sexual abuse goes, she herself did not participate in it in the way that Epstein did. However, she herself did some very unspeakable acts, and I have a very hard time being a woman myself, sitting back and knowing that a woman could victimize children, girls, when, growing up, I was always taught, if there's stranger danger, you find a woman, because you can trust her more than you can ever trust a man. And she is not that type of person at all. She would chew you up, spit you out, and throw you to the wolves. She's disgusting. I hope she spends the rest of her life rotting, being uncomfortable in jail, because I know how much she hates it. And she continues to be a whiny little bitch who refuses to testify, who refuses to do anything to make amends for what she did. She has no remorse, which isn't that big of a surprise, but it does suck nonetheless. And then to make matters worse, her lawyers feed into the behavior. This document, I'm not going to read it, but it talks about the fact that she, in particular, was concerned about the members of the jury being biased because the case was so publicized and it just wasn't fair and everybody was going to know about it. And to be honest, when you get cases like this, there's really no way in hell you're going to get a completely unbiased jury. And to help, solidify how much of a biased jury that this was, they brought up specifically the amount of Google searches for Ghislaine Maxwell, which was 4,590,000, and for Epstein it was 25,800,000. And then they provided a list of documentaries, podcasts, books pertaining to Jeffrey Epstein and Ghislaine Maxwell, and how because the media was so mass-produced and so widespread that, nothing was going to be fair for her, and they needed an unbiased jury, and how some people would even have implicit biases, which weren't fair either. So instead of just doing the juror questionnaire, they were asking for private questioning of jurors to, help determine the best shot that Maxwell was going to have. And I think it's ridiculous. I think it was a stalling tactic, and I think Maxwell was just bitching about it because she didn't like the situation she was in, and she was grasping at straws to get out of it. Again, We have more complaints from Ghislaine and her lawyers. The top part. Two things want to discuss: recent developments related to conditions in MDC, as well as a renewed bail application, which they're planning to make. These are notes, so they're shorthand. Another thing that her lawyer says: recent conditions are that yesterday Maxwell was whisked out of an area she spends the day in. She was asked what was going on. And they told her that they were giving her a test, and she wanted to speak to her lawyers before they gave her a test. But she was told that if she did not take the test, she would be put in SHU for 21 days. And if she did take the test, she would only be in there for 14 days, then given 2 COVID tests. Apparently, staff that were near her had tested positive for COVID, were coughing, and apparently she was told that that person had COVID. Now she's in her isolation cell, and every time they open the hatch, they spray it so chemicals are in her area, which is a big issue. And that they repeatedly search her, strip search her, wand her, and then after the search, they get up close and personal and look into her mouth, which is, it defeats the purpose because it is an invitation to an infection. She also goes on to complain to her lawyers about not being able to write properly because she doesn't have a writing desk. Well, newsflash, they don't give you fucking writing desks in jail, Ghislaine. Then she goes on to talk about how the conditions under which she was detained were too severe because clients for terrorism, violence, and murder have never been treated the way that Maxwell has been treated, which I disagree with. They go on to say that they've never seen anything like this and that, it's illegal, and they talk about wanting a bail application. Then they go on to discuss that, the wanding and the searching might be a little bit extensive, but it's not the end of the world. They talk about the bail application, and then it just continues. So that they talk about, one of the staff members on detail who works in the area where clients are housed tested positive for COVID, and that everyone who works in that area was sent home to quarantine, and that, even though this happened, Maxwell's test came back negative, but they still had to send it out to the lab, and that she still needed to stay in quarantine for 14 days before testing out, and was told that she had to stay in an isolation cell. Again, they talk about the searching issues, and then the U.S. attorney says, she has 3 hours a day to make legal phone calls, and she is able to review discovery for 13 hours a day, which is more than anybody has ever been allowed to do as far as that goes. And then the attorney for Ghislaine says, anytime anything is given to her, they open the hatch, and every time it is opened and closed, it is sprayed. Chemical of spray goes into the room where there is no other ventilation. She also has no hot water soap, and she's not able to self-protect under these conditions. Again, it's all freaking stupid shit. And then they get down here. She's practically in solitary confinement. Yeah, that's what that is with COVID. When I visit her, there are at least 3 people watching us with a camera. I have asked what the camera is for. They say it is not recording. Then why is it always set up and moved when they move us? Degree of invasiveness of attorney-client relationship, which I've not experienced before. She doesn't even have a regular toothbrush. It's 1 inch. So, again, Maxwell is just bitching left and right about normal contents, normal conditions of prison. Again, going back to my juvie experience, okay? I wasn't there at COVID. I came in just after COVID was relieved, but my coworkers told me that if kids tested positive for COVID in a pod, that entire pod was placed on quarantine. They were not allowed out except one at a time, to the point where kids were having legit mental health crises because they started to hear shit. Because isolation's not good for people, but if they're doing this doing this to kids to keep kids from dying of COVID, and a grown fucking adult cannot handle that, cry me a goddamn river. Cry me a fucking river. My toothbrush is only 1 inch long. Yeah, most toothbrushes are like that so you don't kill yourself. Since Epstein did it with a fucking bedsheet he wasn't supposed to have, the kids in juvie have like 1 inch toothbrush so that they can't shank each other and they can't kill themselves with it. That's how it is. No, you can't have a writing surface because guess what? You don't get to just have whatever the hell you want in jail and prison, Maxwell. That's not how it works. Oh, well, they were spraying chemicals on the door hatch. Yeah, Have you ever thought that maybe, just maybe, if you're opening a door hatch to pass food through it and you're making contact with people and there's trays where people's spit and food and saliva have gotten onto, like if they had an apple and they ate an apple and they put the apple core on the tray to give it back, when COVID's an issue, that maybe you would want to wipe that surface off so disease isn't transmitted? Like, it's so infuriating because it's so dumb. And she's allowed to act this way and have these things entertained because of the type of person that she is. And if she's going to be in jail or prison, she is going to make it everybody else's fucking problem. And that's just who she is. And it was so infuriating reading all of this because I wanted to just be like, dude, shut up. Nobody cares. Nobody cares about sad little Ghislaine Maxwell in a box. How dare she have a 1-inch toothbrush? Welcome to the real world, sweetheart. Imagine everybody else who's been dealing with this shit for years that hasn't bitched the way that you have. Again, a testament to her true personality. Here we have a document that talks about how a press release was held in front of Epstein's mansion, which people were not happy about. And I think the last few things that I have to go over, because we are getting towards 2 hours, is something that I also find particularly interesting and will research more on. So, here we have something that was written by somebody who I did a little bit of digging. It was written by this individual. Now, I can't quite tell what the signature says. I think the first name is Ray. And I think that's another... I think it says Ray, but I'm not entirely sure. If you're watching this, please let me know what you think this signature says. But this is from somebody who works at Sparta Security Services. And what this is somebody who wrote a document pertaining to the private security that they ran for Maxwell prior to her arrest, in which they compare Maxwell's paparazzi issues to Princess Diana's paparazzi issues, and we all know how I feel about that. Where we're going to read a little bit of this, because this is what happened before she was arrested. According to the protocol, Miss Maxwell was to move away from the windows if possible and move into a safe room inside the house. This is normal protocol in these situations. A safe room typically has water, food, and communications. It is also able to be locked and barricaded from the inside to ensure it gives enough time for a 911 call to be placed and the police to arrive before exposure to the threat. Blank reported to me immediately after Ghislaine Maxwell's arrest. He confirmed to me that after radioing Miss Maxwell, 1 or 2 vehicles pulled up and stopped near where Blank was standing. He was told to stop and move no further by a number of individuals who got out of the vehicles. At that time, he could see that they were federal agents because they were wearing FBI jackets and had weapons visible. The agents physically searched Blank and questioned him. Blank was later taken to a vehicle where Miss Maxwell was sitting. She asked him if he would look after the dogs and the cat, which he agreed to do. I understand that as part of her renewed bail application, Miss Maxwell is proposing a substantial bail package that will include the following conditions, among others. 1, Miss Maxwell will surrender all of her travel documents, and 2, she will be subject to home confinement with electronic GPS monitoring. I also understand that upon release, Miss Maxwell will be monitored 24 hours a day, 7 days a week by our security teams. In light of the proposed bail package and the strict conditions of her confinement post-release, as well as our long-standing relationship with Miss Maxwell, my company will be posting a $1 million bond in support of her bail application. I have never once posted a bond for a client in the past. I am happy to post a bond for Miss Maxwell in light of the factors discussed above and my relationship with her, because I am confident that she will not try to flee. So this is really fucking weird to me. Of all the people for your company to post a bond for, $1 million for, by the way, you pick Ghislaine Maxwell. And your excuse for that is that you are confident she will not try to flee based on your personal relationship with her. Now, in this document, he talks about how he's known her family for a long time and he's run security for her before, and how she's had people make harassing statements and death threats and everything. But I do think it's weird. I think it's very suspicious. I don't know why you would put your personal security company on the line like that for somebody like Maxwell. I don't understand it. I'm going to look more into the security company, because to me this is a red flag. I may look into it and find nothing, but that's why you don't take things at face value. You can trust your instincts and say, hey, that's a little bit weird, And, I want to look into that more. But I'm not going to say right off the bat that these are bad individuals. I just think it's a little bit fishy. And I think you guys would probably agree. I also want to know what that signature says. I think it says Ray Ray. I don't know. If you guys can read that a little bit better than me, please let me know. But that's basically all I've gotten up to. I've read about 12,000 documents at this point in total. It is a lot. I'm still going. I don't know if and when I'll ever stop, to be honest. The more I read, the more I keep going. But I also know, realistically, how am I ever going to read 3 million documents? And then eventually there's going to be 10 million documents. So it's a lot. I guess I'll just keep going until I feel like my questions are satiated. That may be a while from now. So if that's something that you want to keep up on and know that I'm going to report specifically from the files themselves, please don't forget to like, comment, and subscribe. I am going to caution you guys. I know I've posted a video on it before, but there are people out there who are farming content not for good reasons. Mine is to be educational, to be informative, to help people understand what is in the files, what they're seeing. That is why I include screenshots of the actual documents, so that you guys know I'm not bullshitting you. However, there are individuals who do not do that, who are running rampant on social media, who have millions of views, millions of followers, that are saying things that cannot be corroborated. And right now, a lot of this has turned into a version of the satanic panic. Specifically, I have seen countless videos of people discussing cannibalism, eating babies, and not a single person has been able to produce a document that legitimately has anything to do with that. And I think it's fear-mongering. I think it's inappropriate, because what it does is it takes away from the actual horror of sex trafficking, sexual abuse, child rape, child sex abuse. It makes it this fantastical, gory, topic that everybody wants to talk about because it's so Hollywood-esque. And do I think that it's possible that there are the elite that could be eating and cannibalizing babies? Sure, anything's possible. Do I logically think that that's accurate? No. Because what I'm going to do right now is ask you guys to think of when is the last time you heard of somebody being a legitimate cannibal? Can you think of a name? And if you thought of Jeffrey Dahmer, I want you to think of somebody else other than that. Because as much as I know about, the true crime world, I can't think of anybody other than Jeffrey Dahmer. And you want to know why? Because cannibalism really isn't anything more than a fetish. Biologically and psychologically, humans are designed to not eat each other because it goes against the fundamental evolution of our species. If we spent all day, every day eating each other, we would never actually evolve as human beings. It is why people who are in desperate situations wait until the brink of death to resort to cannibalism. And part of this has to do with morality. But cannibalism as a whole is so incredibly niche that the idea that there is this entire elite society made of hundreds of people who eat babies, logically, I think we can look at that and say, yeah, that's probably not true. And unfortunately, people are taking this information, they are running with it, and they are making content that gets millions of views, and it is spreading misinformation, and it is detracting from the fact that there are children who were sexually assaulted, who were sexually abused, and who were raped. And it didn't have to do with babies, and it didn't have to do with cannibalism. And I don't think that we should be going into that narrative. I think we should be pushing back against that a little bit until there is legit definitive proof. And if I find legit definitive proof that there is evidence to support cannibalism and cannibalism of babies, I will tell you about it. But just because something is said in the Epstein files, just because it is mentioned, Googling a name and finding a name in the Epstein files is not research. It doesn't count. You have to have context. You have to read. You have to know the information that you are absorbing. So I caution you guys with the information that you take in. There are people out there who are doing a very good job, who are being very respectful, who are using context, who are using research, and there are those who aren't. So please take things with a grain of salt. If it feels a little bit weird, that's probably because it is. That's all I have to say. I appreciate you guys being here. This is a 2-hour-ish long video, so it's a lot. But thank you. I appreciate it so much. Please take care of yourselves. Stay safe out there. Don't forget that you're human too. It's very depressing. Do things that bring you joy. I just bought a new comic book, volumes 1 through 12 of Dark Knights of Steel, DC comic. I'm a huge nerd. Don't forget to enjoy life. That's important too. So please stay safe out there, take care of each other, and stay psyched out.